Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest, I'm going to start over there because I botched the beginning there. Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Anthony Michael Kreis, Visiting Assistant Professor of Law at Chicago-Kent College of Law. We will discuss his article, Dead Hand Vogue, which will be published in the University of Richmond Law Review. So welcome to the show, Anthony.
Oh, thanks for having me back.
Yeah, it's so great to have repeat guests. You know, the show's coming up on the 1-year anniversary pretty soon, and it's nice to have people like you coming back to do second episodes and kind of see, you know, different kinds of work that you're doing.
Yeah, well, thank you for having me, and congrats on the podcast success. It's just so great to see so many academics and students and practitioners have access to the things that we're doing. So I think it's really remarkable how much success you've had with that.
Thank you. It's been a lot of fun. So this paper has been seeing a lot of success as well. Among other things, it's like one of the best law review article titles I've seen in a long time. And I want to talk to you about that a little bit after listeners have a sense of what you're actually doing substantively in the paper. But, you know, the paper really is about the sort of history of the conceptualization of Title VII employment discrimination law in relation to LGBTQ individuals. But I was wondering if, as a way of kind of introducing the paper, you could talk a little bit about how courts usually conceptualize Title VII in relation to identifying and remedying employment discrimination.
Yeah. So I'll start with, the main core part of Title VII, which is Section 703A1. And that part of Title VII says that it's unlawful for an employer to discriminate against any individual because of such individual's race, color, sex, or national origin. And so there's a couple of things that are important there, right? The first is being any individual. And the second thing are the different kinds of reasons employers are barred from using as a general matter in employment decisions. So the issue here, and this is an issue that we see kind of the constitutionalization or I would say the invasion of con law into Title VII doctrine, is that the things that are protected under Title VII are characteristics or traits. But a lot of times people will talk about it as protected classes. And that doesn't really get to the heart of what Title VII really does, because Title VII does much more than protect against ontological discrimination, right? So it's not just, for example, we don't allow companies to say, well, we will hire men but not women, or we will hire people of this particular faith but no others, right? We construct Title VII, and courts construct Title VII differently. So they look at what traits may have come into an employer's decision-making calculus. So, for example, mothers with young children. If an employer discriminates against mothers with young children because the employer has some background assumption that women with kids, particularly those in, we'll say preschool age or elementary school age, you won't be dedicated to the job or will be, kind of absentee employees. That kind of stereotyping is unlawful because they took that employee's sex into account. And so you can have unlawful forms of discrimination that only impact subsets of groups. So, right, in this instance, women, not all women, but women with children, right? So the difference here is that, right, a woman's or a female employee has been sex stereotyped because she's a mother, and that would be an unlawful form of discrimination. So in essence, the way Title VII works, right, is it protects individuals whenever a protected trait is unlawfully considered in an employment decision.
So if I understand it correctly, then it's like we sort of talk about Title VII anti-discrimination law in relation to classes, but in actuality, with respect to most quote unquote classes of people, the courts actually look to traits that are specific or potentially specific to individuals rather than traits that are uniform to the class itself. And if that trait is in some way related to or tied to the category that is prohibited to be discriminated against, then that's enough for discrimination. In other words, they're looking to what individuals are like rather than just to the limited kind of class as a whole.
That's right. So in the same kind of vein as the women with children, if an employer felt like a man who was a primary caregiver wasn't worthy of employment because the employer had some vision of men being less manly or less reliable of a potential employee because they are the primary caregiver of children, right? It's the same thing. If you're taking the trait into account and then making an adverse employment decision because of that trait, that's unlawful. So you're exactly right.
Okay. So how is it then that courts have conceptualized or applied Title VII differently with respect to LGBTQ individuals?
Yeah, so what, it might be helpful to just start on why I was thinking about this issue, because I've thought about these cases for a long time, and I've written about them, and I've taught them, and just thinking of just as they marinated with me, I thought there was a few things that always stuck out. There always seemed to be very little analysis in these early cases where LGBTQ workers said that sex discrimination, the prohibition of sex discrimination covered LGBTQ discrimination claims. So in other words, that sexual orientation discrimination is a subset of sex discrimination, or gender identity discrimination is a subset of sex discrimination. And these early cases from the mid to late 1970s and throughout the 1980s just had no analysis. So that struck me as interesting. It struck me as interesting that for many of these cases, legislative history was dispositive of the analysis. So there was a lot of discussion about why LGBTQ workers weren't covered, cloaked in the idea that, well, Congress in 1964, when the Civil Rights Act was enacted, never intended or thought about or discussed LGBTQ workers, and therefore they must be excluded. And that seems very out of place for most of us thinking about statutory interpretation and construction today, because textualism is the touchstone and the primary driver of statutory analysis, and we've really kind of grown away from relying on legislative history to the extent that these early cases do. I also was struck by the fact that a number of judges actually understood the arguments about the relationship between sex discrimination and LGBTQ discrimination, and I think we could talk about that later. And then the other thing that struck me as just being profoundly strange was that the judges in this period, when they were talking about what groups were and were not protected under Title VII, just collapsed and conflated different types of identities within the LGBTQ community and showed a complete lack of cultural competency. So they would say, well, transgender people, gay, lesbian, bisexual people, and cross-dressers are all not covered under Title VII, and that's that. Which just seems right to us today, where we have so much nuance between gender identity discrimination, different forms of sexual orientation discrimination, and we see that the LGBTQ community is not a monolithic community, right? There is a lot of diversity within it, that these cases just grouped all these different kinds of folks together in order to keep them out of Title VII's protections. And when I really dug into it, I came to the conclusion that the problem with all of these early decisions was a fundamental error that the courts did not recognize, and the courts just glossed over the idea that Title VII protects individuals and not groups. And that lack of an individualized focus, right, where the traits weren't important, but the group identities were, allowed for the legislative history to come in and allowed for the legislative history to dominate the analysis, and it was all performative. Because it didn't really mean anything, right? They didn't really truly engage in the relationship between sex discrimination and forms of homophobia and transphobia that these workers were up against. And so, right, in a sense, you had this kind of interactive effect where the lack of a focus on the individual amplified the effect and the impact of the legislative history in a way that is so inconsistent with Title VII's text, and I think it's a warning sign for the courts, the Supreme Court now, to avoid this kind of groupthink. And the paper shows how Title VII has actually done a pretty good job in the space of increasingly focusing on the individual. And I think we'll have lots of time to talk about that. But the more the Title VII has, veered towards individual level analysis, the more protective it is and the more true it is to the text.
Mm-hmm. Well, so in your paper, you talk about the concept of a legislative dead hand. And I wonder if you could say a little something about that, what that means, and how the kind of concept of a legislative dead hand has affected judicial interpretation of Title VII in relation to discrimination against LGBTQ individuals.
Yeah. So the court's decisions from, again, the 1970s and 1980s, all are looking at the way, or trying to divine the intent and the thought of the legislators sitting in Congress in 1964, right? And so they're just, the courts are bent on preserving this idea that because the individuals who wrote Title VII, when the ink dried, had no intention and no belief that LGBTQ people were protected or should be protected, that kind of ideological perspective should be kind of baked in the cake. So as soon as the ink dried on Title VII, whatever background thoughts legislators had about LGBTQ people, right, are inextricable from the text at this point, right? So it's the courts are looking towards what these legislators, are trying to, impose an idea of what these legislators thought about LGBTQ people, and saying that, once that, once the legislative drafting was done, which was meant to protect men and women and nothing else, that's what we have to adhere to. And we really shouldn't be open to evolving understandings of what sex discrimination means. And I think that the courts really got that wrong, again, because they weren't thinking about the individual level a problem here, or they really weren't taking the individual's claims seriously, and that's a problem, right? Because when judges look at LGBTQ employees' discrimination claims on an individual level and take their theories seriously, the text really does do the work here, and I think that it's pretty obvious to a lot of people now that you cannot disaggregate sex from sexual orientation or gender identity. And so if you do discriminate against someone because of their sexual orientation or gender identity, you are doing it, looking at their sex and taking their sex into account. So the text really does drive this, and it shouldn't be, as the courts in the 70s and 80s would have had it, right, the ideological baggage of Congress in 1964.
Yeah, I mean, one thing that really struck me when I was reading your paper was there was a way in which there's this kind of slippage between saying, well, Congress wasn't thinking about LGBTQ discrimination in 1964. Therefore, we don't read it into the statute. But it almost seems like it becomes like because they weren't thinking about it, they were intentionally excluding it and thereby implicitly endorsing it. And therefore, in a weird way, sort of baking in a kind of homophobia into Title VII itself, to the extent some of the circumstances you describe almost sound as if the courts are saying, well, LGBTQ discrimination is okay. Therefore, even discrimination that is based on traits that are tied to sex is also okay, because this is like a categorical exclusion or something.
Yeah, it's interesting because Title VII today protects a lot more, I suspect, than what the average legislator in 1964, signing on to the Civil Rights Act, would have thought it protected against. So, right, sexual harassment, the idea that the median legislator sitting in Congress understood sexual harassment to be a wrong thing, and that they were legislating against it, strikes me as absurd. But yet, Title VII rightfully protects it because we understand that sex-based harassment and hostile work environments that target people because of their sex, change the terms and conditions of employment. And so, the fact that Congress didn't think about it doesn't mean that it should be excluded. Our understanding of the application of what it means to be discriminated against because of sex has for the better expanded. Congress probably wouldn't have anticipated same-sex sexual harassment either being cognizable under Title VII. And in a similar vein, you think about the kinds of discrimination that Congress might have thought about, but weren't explicitly perhaps thinking about. Title VII was enacted before Loving versus Virginia. At the time that Title VII takes effect, there is no constitutional right as a matter of Supreme Court precedent for interracial couples to marry under state law. Yet Title VII today rightfully protects interracial relationships from forms of employment discrimination. So I think that the idea that we need to be cemented to a narrow view of what employment discrimination means because of how we predict or surmise the average legislator in 1964 thought or what they were thinking, I think that's wrong.
Yeah, well, one thing that struck me too was like imagine if Congress had written into Title VII something along the lines of, yes, all this, but explicitly discrimination against LGBTQ people is okay, right? I mean, I feel like a statute like that or a statutory phrase like that would be, it's hard to imagine how that would be permissible under kind of current under Lawrence and other more recent precedents. But it seems as if because it's almost kind of written into the statute or kind of implied into the statute sub rosa, at least some courts are willing to give it a pass simply because it's sort of the discrimination that dare not speak its name, as it were, right?
Yeah, and the same thing. I guess the flip side of the same coin, there are a lot of decisions over the last 20 years which have expanded the rights of LGBTQ workers under Title VII, and Congress could have conceivably enacted legislation to reverse those. And in fact, there's been legislation introduced not too long ago, I think it was last Congress, to reverse some of the pro-transgender discrimination cases, and to keep transgender individuals outside of Title VII's protection. So, I think statutory interpretation is, it's fascinating because, legislative history, right? What's the saying? It's like looking into a crowd and seeing your friends. And that's basically what this is. And it's too easy to pick and choose. And as someone who has political science training, right? The idea that we can ascribe a single motive to 400, 500 people voting on a piece of legislation and working on a piece of legislation. That's just impossible. So I think that this adherence to what what the framers of Title VII thought would or would not have been covered is it doesn't make a lot of sense to me.
Yeah, no, I agree. And like from the descriptions you gave in your paper, I couldn't help but feel like some of the courts sort of interpreting a sort of carve out or permission for this form of discrimination, almost like projecting onto the 1964 Congress their own prejudices and sort of finding, as you say, kind of finding them in the past, even though they're really an expression of how they were feeling in the present.
Yes. And I think that's right. Yeah.
Yeah. Yeah. Well, and so one thing I was wondering if you could talk about a little bit are some of the truly kind of bonkers results that come out of this interpretation. So like, it seemed almost as if from some of the examples you gave that like this, like anti-LGBTQ discrimination by mistake is prohibited, but intentional discrimination is not. Like, how could that be? And how could courts possibly reach that result, which doesn't seem to make any sense?
The mistaken gay, as I think these cases are, the one I talk about is, you're right, it's absurd. So I'll start with how we, with the basics here. So in 1989, the Supreme Court decided a case called Pricewaterhouse versus Hopkins, and there, long story short, Ann Hopkins was mistreated because she was perceived as being too masculine, not wearing enough makeup, or being a little too a little too rough on the edges, and so she was denied a partnership because of these prescriptive stereotypes, which were essentially requiring her or wanting her to conform to a gender role where women are very feminine. And the court there said, well, these kinds of prescriptive stereotypes are just as unlawful as descriptive stereotypes. So descriptive stereotypes being assumptions. So like going back to the mothers with young children, there's an assumption that all mothers with young children are undedicated workers, and that's used to then discriminate against individual employees or potential employees. Prescriptive stereotyping is just the it's kind of the individual level policing of an employee to broader gender norms. And so after this, there were a lot of transgender discrimination cases which were successful because trans employees were able to say, you're doing the same thing to me as Pricewaterhouse did to Ann Hopkins, trying to police gender norms and gender roles. But the weird twist came with the sexual orientation discrimination cases. So a lot of men and women who were lesbian, gay, and bisexual would bring claims, and they were successful so long as they showed that it was because of similar gender typing and with prescriptive stereotypes. So in other words, effeminate men could have a claim, and masculine women could have a claim. But of course, the line between discriminating against, for example, an effeminate man and someone who is gay or presumed to be gay, a gay man, these things bleed into one another. So, but nonetheless, courts said, well, because groups, gay men as a group are not covered under Title VII, if your claim looks a little too much like anti-gay discrimination and not enough like effeminate male-related discrimination, we're going to toss it out. So you get all this kind of that in itself doesn't make any sense, right? I mean, that should make most people's minds kind of explode. But you get these weird, you get this weird result, and this case, there was a recent case from Pennsylvania where this woman, her supervisor was just awful to her, said that she had a lesbian tattoo and told everyone in the office she was a lesbian. but there really isn't a lot of evidence to suggest that she necessarily thought, by the supervisor, thought that the employee was overly masculine. But the court kind of assumes this is the case, because why else would she assume that she was a lesbian? Because, surprise, the employee wasn't a lesbian. The employee was, in fact, a heterosexual woman married to a man. And so, there's almost kind of this default assumption that if a heterosexual is discriminated against because others think, for example, here, that the woman is a lesbian, she must have given off some masculine signs or something, right? And so she's got a claim right under this Pricewaterhouse gender nonconformity prescriptive stereotyping doctrine. But the court in this particular instance with the lesbian tattoo case admits that if she were actually a lesbian, she'd probably be, either out of a remedy altogether, or would have a much harder time than what she did. And so you get this crazy distinction between, people who litigate. It's kind of like, if you're litigating while gay, you're in trouble. But if you're litigating the same set of facts, but you're a heterosexual, you'll be okay. And that just can't be, right? It cannot be the case that someone's group identity suddenly removes them from the same protections afforded to someone else because they identify in a particular way. And that's inconsistent with the idea, right, that we protect against traits and not protect groups. So I think these cases are they're just fascinating, but they illustrate the point in a really on the nose kind of way.
Yeah, I mean, in a weird way, they sort of imply or even straight out say that discriminating against LGBTQ people on X basis is permissible, but discriminating against heterosexual people on exactly the same basis is not. It's like turning Title VII into anti-discrimination for straight people, but not for gay. But that's just wait, what?
Yeah. I mean, in a way, it almost kind of gives rise to this heteronormative supremacy, right? Like, if it seeks to, that construction preserves this heteronormative, kind of default rule. And it just seems very, it's logically indefensible. But I think, again, you're right. It highlights that the law can't just keep someone out of its protection simply because they identify in a certain way, even if the facts are in their favor, as illustrated by it applying to someone with a different identity. It's just, it's hard to really assail even, in any really more significant way than that, because it is so patently absurd, I think.
Mm-hmm. Mm-hmm. Well, so maybe you could talk a little bit from a kind of doctrinal perspective, how Title VII, the application of Title VII in relation to LGBTQ rights would change if there were a kind of doctrinal shift from thinking about this as a class or group analysis to an individual analysis. In other words, what would be different, and what would the law look like if it were conceptualized in that way instead of the way that kind of historically courts have conceptualized it?
So the short answer is the law would be very clean, which I think judges and lawyers and law professors like. So the Seventh Circuit in Hiley versus Ivy Tech, and in the Second Circuit in Zarda versus Altitude Express, and that is the Second Circuit case is the one that's now at the Supreme Court. I think put very straightforward arguments as to why sex discrimination includes sexual orientation discrimination. The simplest way to describe it is you cannot take someone's sexual orientation into account without taking their sex into account. So if I have an employee named Sarah, and I'm totally fine if Sarah is dating Bob, but if Sarah is Sean and Sean is dating Bob and I'm not okay with that, it's because I've taken Sean's sex into account and Bob's sex into account and I put it together now and said, oh, right, he's in a same-sex relationship and I don't like that. And I'm taking that now into my employment decision calculus, and therefore, right, that's taking sex into account. You cannot, right, there's no way you can really parse the two out from one another. And I think that's a very straightforward textualist approach that, right, it's no different than any of the other cases that we've talked about so far and how traits are used in that, in that kind of framework. Now, there's a couple other ways. There's a sex stereotyping rationale that says, right, we have an expectation that men should date women and that women should date men. And so if you run afoul of that sex stereotype because you're in a same-sex relationship where you're attracted to people of the same sex, that violates Title VII. And that's, I think that's probably the harder framework to use that for folks on the fence to buy into. But the third one that's important is called associational discrimination. Now, I don't think associational discrimination is really all that different than the first very textualist-based approach I articulated a few seconds ago. But it's essentially this, that that if you discriminate against someone because of a protected trait of the person that they're associating with, that's unlawful. So, for example, there's a landmark case called Parr, Parr. It's from the 11th Circuit from the mid '80s, and Mr. Parr was a white insurance salesman, and was looking for a job, and he was denied the job because he was married to a black woman, and the 11th Circuit made it very clear that that was unlawful race discrimination, because even though they had these employer or this insurance company in Georgia presumably had no problem with Mr. Parr because he was white, right? That they would really have a problem with him being in an interracial relationship. They still took his race into account as a white man in a relationship with someone who wasn't. And so that logic, that framework, is arguably transferable here. That if you take someone's sex into, their sex association into account, you're doing the same thing that that insurance company did to Mr. Parr. And so that is a form of sex discrimination because, again, you are taking the employee's sex into account while making an employment decision. And again, I don't really think that you can disaggregate totally that associational theory with the plain textual theory. They work hand in hand, but I think it is important to illustrate for people how that how that kind of analysis should transfer logically over from race discrimination to sex discrimination. And I want to note one quick thing here too. Unlike the Constitution, Title VII treats all protected groups equally, right? And I'm loath to say groups, but all traits are protected on the same footing for the as a general matter. And that's not like the Constitution where we have tiered scrutiny for different kinds of forms of discrimination. And so for that reason, right, the race discrimination, the interracial relationship discrimination case should 100% just transpose to the sex discrimination context and should do the work here for LGBT employees.
Well, so Anthony, you mentioned that this issue is before the Supreme Court, I believe, in the coming term. I wonder if you could just reflect a little bit on sort of what you hope and expect to see happen in those cases.
I think those are two very different things. So I hope that the court recognizes that the text does the work here for all LGBTQ employees. That you cannot take someone's sexual orientation or gender identity into account without also taking their sex into account, and that's I think that's a straightforward application of both the individualist principle of Title VII and the principle that Title VII protects against trait-based discrimination, and not really it's not about groups. I'm always loath to make Supreme Court predictions, because I'm always either wrong or very wrong. Um, but I will say this: I think that the people on the court to watch, I think Chief Justice Roberts is someone to watch. In oral arguments in the marriage cases before, he articulated the sex-based discrimination analysis and framework that I just talked about, and he mentioned it, kind of sua sponte in oral arguments. And so it's obvious that he gets the logic of it, because he's already been thinking about it years in advance. Well before these Title VII cases were percolating in the court. So I think he's someone to watch, and I think Justice Kavanaugh is the second one to watch, because I suspect that you could get either one of them on board, or both. The other thing that will be interesting in oral arguments to watch is the division between Justice Kavanaugh and Justice Gorsuch, because they have been when they divide, or the divisions and disagreements between them last term were often very stark, and sometimes resulted in a number of 5-4 decisions, some surprising and some less so. But I think we'll learn a lot more by whatever space there is or is not between them. So, I still think it's, frankly, I would put it at 50-50,
Mm.
because I think that the arguments are there. There are a handful of, right, two of the justices who I think would be rather inclined to get these arguments and buy into them. At the same time, there are dynamics that concern me. This is probably more so in the transgender discrimination cases. I mean, ironically, right, the transgender cases have been the easier ones for years to make, and transgender employees have been remarkably successful, and under Title VII and state law. Um, but if but the things, the hot button issues, which really I think are grotesquely employed. Where some of these amici, for example, talk about what will happen with bathrooms and dress codes, and right, the safety of people, and what happens to women, women's identity, women's rights and things like that. There's a lot of kind of all these briefs that just lay out these parades of unsubstantiated horribles, about what will happen if transgender discrimination claims are cognizable under Title VII. I do worry that those could spook the court.
Mm.
I hope that the court realizes, though, that because so many states expressly protect transgender employees, and because Title VII has done a very good job at doing this for a long time, including, and frankly, there's some good equal protection, in the public employment discrimination context out of the 11th Circuit, that they'll recognize that these are in fact, just they're not real concerns, and they're not things that are made out of they're not positions formed in fact or reality. They're there, right, as scare tactics, I think.
Mm.
And I hope the court doesn't buy into that, because I think that if the court does, the damage will go well beyond whatever Title VII rights are shut out from transgender employees, because the court is an important institution, I think, for all the griping I do about it. I'll admit. I think the court does project to society a bigger message about our values, and so I hope that the court really takes a strong position, rejecting these kinds of claims and assumptions and baseless arguments, and does the right thing for all LGBTQ workers. But that is a particular aspect of things that concern me. And the one other thing I'll say that concerns me, because I have a lot of concerns, but I'll leave it to one. Right, Price Waterhouse versus Hopkins is a landmark decision that does much more than protect LGBTQ people, although it has done a lot for LGBTQ workers, but it protects all men and women who might just feel or act or behave slightly differently, who defy gender norms in even the slightest of ways. Price Waterhouse protects everybody, and my concern from a doctrinal perspective is that the court will overturn Price Waterhouse as a way to avoid really having to engage in the serious implications Price Waterhouse has in favoring LGBTQ workers, right? They could just say, well, Price Waterhouse was decided wrongly, we're overturning it, and now all these other cases go away because of that. And yeah, that would harm LGBTQ people, and that would be a disaster for the community, but it would also seriously undermine and harm the rights of every single man and woman who's employed in the United States and is covered by Title VII. And I don't think that can be emphasized enough.
Mm-hmm. So on a slightly lighter note,
yeah.
Anthony, the title of your paper, Dead Hand Vogue, it's one of my favorites in quite some time. And I was wondering if in closing, you could reflect a little bit on that title, sort of how you arrived at it, what you wanted it to accomplish, sort of your use of the term Vogue, which I thought was really kind of it made sense, although I didn't know exactly what it meant, right? And it was sort of intriguing and enigmatic at the same time. So I wonder if you kind of have some thoughts on titling papers and how to do it effectively as a way of maybe even potentially kind of drawing interest in, initial interest in your work.
Yeah. So, it's funny because for a long time, I always, if you read all, well, I guess, you have obviously, but folks have, when they read, I'm thinking like Lon Fuller and right, these older legal academics from the 30s and 40s who had all these very bland titles like the forms and lineaments of adjudication. And those always struck me as, okay, well, I know what that paper is about, but all right. And then there were books that have, with titles like Bill Eskridge had Dishonorable Passions, which I just thought was a wonderful title for a book. I just find titles to be exciting, and so I love coming up with new and interesting titles. More so though when I have symposium piece, right, where I'm more drawing people in on a piece that's already been set for publication rather than trying to convince folks to publish it. But this one, it struck me again how performative the analysis was. And the analysis, really a lack of analysis, but how performative the quote unquote analysis using legislative history, right, the dead hand of Congress as a crutch to basically do, I think, what the judges just wanted to do, which was to exclude LGBTQ people. But I also wanted, so that's obviously where the dead hand comes in. And if to reference the performative aspect, right, I thought of the Vogue. And because we've actually, the last time we were on the podcast together, we chatted about my piece about the history of gay rights and the policing of the LGBTQ community. And I think that I have just whether. I don't know if you've ever seen Paris is Burning. I'm sure you have.
Of course, yeah. Many. I teach it. I teach it in one of my classes.
You know who I'm talking to. I've just always been so inspired by the folks in the 20s and the 30s, and all the way up through the 70s, 80s, and 90s who, were creating a culture of defiance and a culture of resilience. And one of those cultural aspects which escaped from the underground into mainstream society was the Vogue. And so I think for me it was kind of a gesture to that group of people out of respect for all the trials and tribulations they were put through, and kind of in recognition that I see so much of my work standing on, the shoulders of giants in that sense. And so it was, in a way, it was kind of a gesture towards that, while at the same time capturing this idea of performative analysis. So I thought it was, it was kind of a turn of phrase that I thought was interesting and would draw people in, and that was quite accurate to what the piece was describing and discussing, and analyzing. And I think that was kind of a meaningful thing too for me to be able to make that point, even if it wasn't necessarily apparent from first glance for most folks.
Yeah, I mean, I love the way you kind of took the legislative dead hand doctrinal theory and sort of mirrored itself back at itself as a form of auto critique, almost, which I felt you sort of like working that Vogue metaphor throughout the article.
Yeah, no, and like I said, I mean, any listeners who know my recent pieces, particularly again the symposium ones, I love the catchy article titles, and there's just something about it that tickles me. So, so long as I derive joy from it, I'll continue with it to the extent I can.
Well, I certainly encourage it, and as always, Anthony, it's been a pleasure having you on the program today.
Well, thank you so much for having me.
My family claims the right to know what's wrong with me. They say I'm not turning out the way they meant me to be. My mother's given up my marriage. My father's given up his son, the Holy One. 'Cause we're a woman loving women when it's said and done. 'Cause we're woman-loving women, sing it loud and long. Yeah, we're sisters united in love. It's oh so strong. Some say I'm crazy as an Amazon face, but soon they'll see that we're woman-loving women, and that's all we'll be. Survive and throw a loving man around. Well, listen, people, and I'll tell you this: loving a woman ain't one stroke short of bliss. And we're a woman loving women when it's said and done. 'Cause we're woman loving women, sing it loud and long. Yeah, we're sisters united in love. So strong. Some say I'm crazy as an Amazon face, but soon they'll see that we're woman-loving women, and that's all we'll be. people think Sappho was a little touched. I just think Sappho loved that touch we all love so much. And well, woman